everyone, this is Ashley Jamerson coming to you from Costner Law, and today I'm meeting with Ashley Cameron, and the sole purpose of this series that we are doing together is to talk about all the bad things that can happen in real estate. We're going to talk about death, we're going to talk about divorce, we're going to talk about buying a home with your girlfriend or boyfriend. We're really going to dive deep so you are a better prepared buyer and seller when it comes to all of your real estate ties and things like that. So today we're going to talk specifically about what happens to our marital home when we get a divorce. So the first question you guys may have is, do we have to sell our house?
And the answer, as most attorneys will tell you, is it depends. But usually, no, you don't have to sell the marital home. But what usually in a divorce, you're going to find you've made a separation agreement or an equitable distribution order has taken place. So you really have to follow whatever the agreement or the order state. If you're in an amicable situation and you're both coming up with a separation agreement, a lot of times what we see is the two sides will have agreed who stays in the house and how they're going to pay for it, how they're going to split it, and all of those things. When things aren't so nice and amicable, you often see court orders where the court's stepping in and telling people how they're going to separate their properties.
And when I say marital home, I mean, what do they do with all their investment properties that they may have together?
So the term most people are going to look at when they see an equitable distribution situation, court action, is going to be property, any property that was acquired during the marriage that's not been a gift. So even investment properties, if they're doing a bunch of rental properties, anything like that, is going to still be considered marital property. Now, it's not the marital home in that sense where they lived, it's not their residence, but it's still considered marital property because they purchased it during the marriage, and if they're both involved and contributing, then the court's going to look at dividing these things up in an equitable, what they consider fair way. And North Carolina is a 50-50 state.
Awesome. Yeah. And this is only regarding North Carolina. I'm not licensed in any other state.
Neither am I.
Awesome. So we don't know what's happening in like Philly and stuff like that. So we've discussed equitable distribution. What about if things get really bad? Can I basically not me because I'm happily married, but can my client make their spouse move out and then take possession of the house?
So exclusive occupancy or forcing someone to leave is not something easily done. In fact, you can't just go and change your locks and
even though you might want to.
Yeah, even if you want to, you can't really change your locks and just lock your spouse out of the house that they have rights to. That is kind of a no-no. What you can do is, and it's kind of rare, is only in cases usually where there's domestic violence, some kind of protection order. Usually you see an exclusive property rights order from the court with regards to that. And occasionally I think you can ask for the house as part of the child custody order. I'm not a family law. I'm not a family law attorney. It's not something I do on a regular basis. These are just things we see occasionally in the course of dealing with real estate and different orders that we see with people coming in trying to sell their homes or buy other homes. So that's one of the other times you see that.
So what happens if they break up? It's not a marriage, but they maybe purchased a home as boyfriend and girlfriend. They never got married, and only one of the persons is on all the documents. Does that person not on the documents have any rights at all?
No, they don't have any rights at all. You, if you're going to be a part of a household and you don't want to take the step of actually getting married, you better make sure you take the steps to protect your interests, and that interest would include putting your name on the deed, making sure that you have joint tenancy rights. If you don't have your name on anything, you have no rights to the property.
I was always under the assumption that North Carolina was, what is that called when you're married? When you're not married.
Common law?
Do we have common law marriage? Is that like a new thing, or was it ever a thing?
It's not really recognized, no.
Really?
And South Carolina, I think, just chose to get rid of it.
Oh, wow. Yeah. Because there's lots of older people who never got married.
Yeah.
So
you have to, you cannot be married and own a property together, and there's ways to title it so that both sides have equal rights, but you just have to make sure you're doing that. Otherwise, you could potentially put money all into this house, not have any rights to it at all. So you have to take care of yourself.
So recently I've had a lot of single women purchasing homes by themselves. Like, what are some ways that they can protect themselves when they have the mindset of, I bought this house by myself, I want to sell it, own it, I don't want my future husband to be involved with this particular house? What can they do?
So the best thing to do is to do a prenuptial agreement. Prenuptials don't have to be complicated. They don't have to be extensive. If you just wanted to address the properties, that's the best way to go about it, and that's normally what they're for anyway, is to say, hey, I had all this stuff before I was married. I want to maintain some ownership without the marital interest attaching, and that's the only reason for it. Free traders are another way to do that, but usually that's when you're already married and you're looking to go purchase something else. So once you become married, you can do a free trader so that you can buy and sell properties freely.
That's scary though. That's interesting. Well, okay, so they did a free trader agreement. Somebody purchased a bad investment. Would that attach to the spouse, or was she?
If they did a free trader, it does not attach. That's
so it
the
could
point.
Protect and protect. Two ways.
It's just saying that I'm going to own property without attaching any marital interest to the properties.
Okay. So the reverse of that is if a single woman purchases a house and she gets married and she wants to make sure that her spouse is protected. Now she can do a will, but do you recommend?
The best thing to do is if you own a piece of property, then you get married and everything is wonderful and you trust them and everything's the way it should be, you can go back and quit claim to change the interest to you and your spouse, so that both of you are on the deed. Now, it's good to know that even if you don't do that, as soon as you get married, part of the property becomes marital interest. It's the minute you get married, without any kind of prenuptial or free traders, without a prenuptial, as soon as you get married, there's 50% interest attaching to your spouse.
Okay, interesting. If the spouse is a cheater, if he cheated on you, does that give you the non-cheating spouse any leg up in the negotiations with the whole equitable distribution?
Not really. Equitable distribution basically looks at the property and the values of the property, and it does so in a more unbiased. The court tries to look at it more unbiased. They're looking strictly at what you own, what your values, debts, and property is, and then they try to split things evenly. The only time you would see cheating, or what they call that marital misconduct, is in an alimony situation where you're trying to go for alimony. But that's
handled
not
outside of
that's
you.
completely not me. But that is the one time you can find infidelity to be used against the cheating spouse.
Okay, so we're going to circle back to question 1 when I was saying, do we have to sell the house? I keep on saying we, but I'm happily married. So do they have to sell the house? And if they do sell the house, who all needs to sign?
So if the court orders the house to be sold, that's going to be when the house has to be sold. The court's going to say in the equitable distribution, the house needs to be sold and all the proceeds are split. However, the court tells you exactly how to split them. And it's usually going to be based on the whole equitable distribution decision and when they've looked at everything. So when they do that, it will still require both people to sign. If you own a piece of property, it's going to take 2 to sell. We always say 1 to buy, 2 to sell when it comes to marriage in North Carolina.
They don't necessarily have to come into the same office and sign.
No, in fact, a lot of times if I'm told in advance that they are not so happily doing so well together in the same room, then we will separate them.
Okay. So I think that answers all of our questions concerning what happens to the marital home when there's a divorce. If you have any questions, Ashley is going to post this video on her Facebook page and she'll leave it open for you to ask questions. If you are inching towards a divorce, like recently separated, she'll be able to help you there. She's a great attorney, so she'll make sure that the process is as easy as possible, even though the overall process is very difficult. If you are forced to sell your property, I can definitely help you list and sell your property for top dollar, and then communicate with Ashley to make sure that we deal with all this equitable distribution stuff. And I've been known to highlight things pink and blue to make it easy. All my contact information is below. All of Ashley's contact information will be below on her channel as well. Like, share, and subscribe this video, and I will talk to you soon. Bye.